For this module, we are going to talk about wrongful convictions, which include issues of interrogation and false confessions. Approximately 5 to 10% of the prison population is factually innocent of the crimes which they were convicted. This can be due to false confessions, issues of evidence, which we talked about in the last module, or coercive interrogation techniques. In raw numbers, that means as many as 200,000 innocent people are currently imprisoned. And out of these estimates, 15 to 25% of known exonerations are false confessions, and 30% of DNA exonerations are a result of false confessions. Meaning that 30% of cases that have been proven through DNA to exonerate the individual, they found that 30% of those are a result of false confessions. In this graphic, we can see how both false confessions and issues of evidence contribute to wrongful convictions. So why does this happen? Well, it can be due to issues of mistaken identification, junk science, police misconduct, prosecutor misconduct, or having a bad or inexperienced lawyer. Trust me, all of these things can and do happen. So in the previous two modules, we discussed issues of mistaken identification. With regard to junk science, this can include a failure to collect or preserve the evidence, mishandling of exhibits, poor or false forensic examination, as well as the use of unqualified experts. It is important to note that the identification, testing, storage, handling, and reporting of any piece of forensic evidence involves a number of people. Typically, evidence moves from a crime scene to a lab, and then after the reporting of the results is entered into storage. If there is a trial, then the evidence may move back and forth. At any point during this process, evidence can either be deliberately or accidentally mishandled. At the crime scene, evidence can be planted, destroyed, or mishandled, while at the lab, evidence can be contaminated, poorly tested, consumed unnecessarily, or mislabeled. During the reporting of the results, the findings can be misrepresented or misinterpreted. Now let's move to police misconduct. As we have seen in all too many movies and television shows, the police can pick a suspect and ignore any evidence that does not confirm their beliefs. As we talked about in the previous module, this is referred to as confirmation bias. During the interrogation process, investigators can engage in trickery and deceit, which means that they use manipulative tactics designed to coerce a confession, regardless of the truth in the situation. Police can also rely on the use of snitches, which can go horribly awry, especially when they make promises to a snitch in exchange for testimony. In those situations, it is really difficult to discern what the truth is. There is always the possibility of detectives tampering, concealing, or destroying evidence, and there is also witness intimidation. For example, intimidating the wife of a suspect for her to give incriminating information about her husband. For obvious reasons, guilty suspects usually resist confessing their crimes, and it's the investigator's job to break down that resistance. Their techniques have evolved over more than a century, with techniques becoming increasingly more sophisticated. Prior to 1930, police frequently used beatings and brutality to extract confessions. Varieties of physical abuse included beating suspects with fists, gun grips, rubber hoses, and blackjacks, burning the skin with cigarettes, use of electric shocks, twisting a man's testicles, and dragging or lifting female suspects by their hair. But in 1931, a government commission produced a report that became a major catalyst for reform. The report on lawlessness in law enforcement documented this widespread abuse and refocused attention on the treatment of suspects in police custody. This led to a shift from overt methods to covert methods of abuse that did not leave any physical trace. These covert forms of brutality included pushing a suspect's head into a toilet, almost to the point of drowning, or holding an uncooperative suspect by the feet so that they hung upside down out of a window or in a tall stairwell. Phone books could be stacked on the head of a suspect so that when the books were hit with a nightstick, it would produce excruciating pain but leave no bruises. Suspects might have been forced to stand upright for hours. This physical abuse could be combined with deprivation, isolation, and intimidation. Sleep deprivation was especially effective. A series of legal decisions pushed police away from covert physical brutality towards more psychological forms of coercion. For example, the good cop, bad cop approach, where two interrogators work as a team and the bad cop shows anger and expresses the belief that the suspect should receive the most severe punishment. The good cop will show sympathy and understanding with the hope that the suspect will confess when the bad cop leaves the room. One of the most widely used techniques currently is the REID technique. It was created by a former polygraph examiner with the Chicago Police Department. The method claims that if used properly, it can accurately identify liars 85% of the time. The first phase involves a non-confrontational pre-interrogation interview that is dedicated mostly to the diagnostic task. So as you can see, there is already an underlying assumption. If they have made the decision to interview them, then they must already have a preliminary suspicion of that suspect. The second phase involves a confrontational interrogation that is designed primarily to obtain admissions of guilt. When interrogators go through this training, they are instructed that, as a rule of thumb, believe the suspect is untruthful and should try to deny them any chance to say otherwise. Here is the step-by-step breakdown of the technique. First, in step 1, interrogators accuse the suspect of having committed the crime, whether they're citing real or fabricated evidence. In step 2, the interrogator offers the suspect some possible excuses for the crime. In step 3, interrogators persistently cut off attempts by the suspect to deny involvement in the crime. Step 4 involves overcoming the explanations offered by the suspect to support the denials. Step 5 is an effort to hold the attention of the suspect, who may have become withdrawn after an extended and intense period of questioning. At this stage, the officer must appear sincere and understanding. He or she may move closer to the suspect and use touching, such as a pat on the shoulder, or in the case of a female, a gentle holding of the suspect's hand. By the time the process reaches step 6, suspects are usually showing visible signs of giving up, and the interrogator is directed to maintain eye contact and to move the suspect toward an admission of guilt. Step 7 involves reframing the issue as a choice between having committed the crime for a good reason or having committed the crime for a bad reason. The final 2 steps involve eliciting a full confession and writing out the confession so that it can be signed by the suspect. While the last slide highlighted the step-by-step process, there are several psychologically powerful aspects that deserve deeper examination. Underlying the 9 steps are 4 basic influence strategies: loss of control, social isolation, certainty of guilt, and exculpatory scenarios. The process of interrogation is built on loss of control. Suspects are interrogated in a small, sparse room where every aspect of the situation, including the physical environment, the direction and pacing of the conversation, and the length of the interrogation, are controlled by the interrogator. A key goal is to remove the psychological comfort of familiar surroundings and to communicate in blunt and subtle ways that the suspect has lost control of the situation. In short, the interrogation is a tightly controlled, psychologically disorienting situation in which the normal rules of social interaction no longer apply. This loss of control leads the suspect to feel vulnerable, anxious, and off balance. A second, related strategy of interrogation is social isolation. Suspects are almost always interrogated alone, and this is done to deprive the suspect of emotional support and to minimize contradictory information. The presence of a friend or an ally might bolster the suspect's resistance to persuasion and might lead to additional challenges to the interrogator's version of events. The combination of loss of control and social isolation frees up interrogators to create the social reality of the situation. Police, who are presumably experts in the inner workings of the criminal justice system, can make a variety of claims about the strength of the suspect's case and how the case will be seen by others. Alone, in a carefully constructed, somewhat artificial environment, it is impossible for a suspect to independently assess the interrogator's claims about the crime and the evidence because there's no one else for them to assess them with. The third strategy is certainty of guilt. Indeed, many interrogations begin with a direct accusation that the suspect committed the crime, which is often the step one of the REID technique. An innocent suspect will respond to this accusation with denials, but interrogators are trained to challenge, cut off, and dismiss all denials. If interrogators believe a suspect is guilty, everything about their demeanor conveys a simple message. You did it, we know you did it, and it is futile to continue to deny your guilt. And any judge or jury will see that the evidence will convict you. To impress the suspect with the strength of the case against him and to bolster the claim that denial is pointless, police may use a variety of evidence ploys. That is, they will cite real or fabricated evidence that clearly establishes guilt. Sometimes there is actual evidence that implicates the suspect, such as an eyewitness or other physical evidence. If no real evidence exists, police may lie about its existence. They may claim to have an eyewitness or fingerprints or hair samples or footprints that link the suspect to the crime. Police can often be highly creative in these efforts to convince suspects that the evidence against them is overwhelming. The fourth influence strategy involves constructing exculpatory scenarios. To clear the path for an admission to guilt, interrogators offer face-saving justifications or excuses for the crime. For example, it might be suggested to a murder suspect that he killed the victim by accident or in self-defense. By suggesting, minimizing, or coming up with exculpatory reasons for committing a crime, police imply, but avoid saying this directly, that anyone making a judgment about the act will be likely to recommend lenient treatment, such as if a judge or a jury is thinking about making a judgment against you, they're more likely to be lenient given the circumstance. Interrogation manuals, in interrogation manuals, this technique is commonly known as themes. Exculpatory scenarios work by shifting blame from the suspect to someone else, say the victim or an accomplice, or to the circumstances surrounding the act, or by redefining the act itself. Such scenarios suggest alternative, morally justifiable motives for committing a crime. For example, someone suggested of committing an armed robbery might be asked questions that suggest honorable explanations for the crime, such as, did you plan this, or did it just happen on the spur of the moment? Or, was this your own idea, or did someone talk you into it? Or, I'm sure this money was for your family because you had a lot of bills and you needed it. It's important to know that the strategies of certainty of guilt and exculpatory scenarios avoid direct threats of punishment, such as if you don't admit it, the judge is going to lock you up and throw away the key, and direct promises of leniency, the judge will go easy on you if you just admit you did it. Instead, certainty of guilt implies a threat of severe punishment, and the use of exculpatory scenarios implies a promise of leniency. In combination, all four of these psychologically powerful tactics described are designed to cause a guilty suspect to basically recognize that the game is over and that they have been caught. It is pretty hard for any of us to imagine confessing to a crime we did not commit. To understand a little bit more about how false confessions can happen, it's important to look at the case of Thomas Sawyer. Thomas Sawyer was a golf course groundskeeper whose neighbor was raped and then strangled to death. Sawyer suffered from severe social anxiety, and when police questioned him, he blushed, fidgeted, avoided eye contact, and began to sweat profusely. Of course, this behavior made police suspicious, and they had learned that Mr. Sawyer was an avid fan of TV police shows, and they invited him to come to the police station to assist with the investigation. Of course, he was happy to help, but the investigating officers asked Sawyer to help them imagine different scenarios of how the murder might have been committed. Only then did the interrogators accuse him of being the murderer. At first, Sawyer vigorously denied having committed the crime, but over the course of a 16-hour interrogation, he came to believe that he was the killer. To prove his innocence, Sawyer submitted to a polygraph examination and provided hair and fingerprint samples to the police. It shook his confidence badly when the police lied to him and told him that he had flunked or failed the polygraph test. Still, he could not remember raping and killing the woman next door. And during the time that Sawyer was helping the police, he confided that he was an alcoholic. Knowing this, police suggested that he might have experienced an blackout during the murder. That would account for his memory loss for not being able to remember raping and killing the woman next door. A final lie from the interrogators led to a full confession. They told him that his hair sample matched hairs found on the victim's body. Confronted with the lies that they had hair samples and he had failed his polygraph test, Sawyer became reluctantly convinced of his own guilt. He stated, "I guess all the evidence is in. I guess I must have done it." During the final phase of the long interrogation, police shaped and reshaped Sawyer's memory of the murder by providing him with details and urging Sawyer to incorporate those details in his account of the murder. There are many more cases just like Thomas Sawyer's, such as the Central Park Five. We do not know, and it may be impossible to know, how many false confessions occur each year or what % of the total number of confessions are false. Since the late 1980s, 6 studies alone have documented approximately 250 interrogation-induced false confessions. And of 125 cases of false confessions, Professors Steve Drizin and Richard Leo documented more than 80% occurred in homicide cases. Another 9% involved rape and 3% involved arson. This surprising overrepresentation of very serious crimes is partly because the biological evidence, such as blood, skin cells, and semen, necessary for DNA exoneration are much more likely to be available in cases of murder or rape. It might also be a result of the strong pressure on police to swiftly solve these cases when they are violent. We also know that many documented false confessions are the result of vulnerable people being subjected to the powerful influence tactics deployed in the interrogation room. They may be young, inexperienced, naive, easily dominated, under the influence of drugs or alcohol, of low intelligence, submissive to authority, sleep-deprived, mentally ill, or simply terrified. Studies have shown that 63% of false confessors were under the age of 25, and 32% were under 18. It is interesting that in most cases, juveniles are considered too immature to make their own decisions, vote, smoke cigarettes, drink alcohol, etc., yet a confession would be viewed as reliable in court. Another 22% were considered mentally retarded, and 10% had a diagnosed mental illness. Interestingly enough, multiple false confessions to the same crime were obtained in 30% of the cases, wherein one false confession was used to prompt others, such as, your accomplice confessed to the crime, so we know you did it, so we need your confession. As noted previously, confessions obtained from juveniles are often unreliable, as children can be very easy to manipulate and are not always fully aware of their situation. With regard to mental disabilities, sometimes those individuals have falsely confessed because they are tempted to accommodate and agree with authority figures. Furthermore, many law enforcement officials are not given any special training on questioning suspects with mental disabilities or how to detect signs of a mental disability. It is important to discuss the length of the interrogation, since some may reach the point of exhaustion and believe that in order to go home, they'll just confess and prove their innocence later. In most false confessions, the person reaches a point where confessing seems more beneficial than continuing to maintain their innocence. Let's talk about the types of false confessions. This breakdown is somewhat different from the categories in your book. We will distinguish between instrumental and authentic, and voluntary and coerced. Instrumental confessions are those offered as a means to an end, to achieve some goal. Often the goal is simply to bring an end to the highly aversive interrogation. In contrast, authentic false confessions are the result of a confessor's genuine but false belief that he or she may have actually committed the crime. An instrumental, coerced false confession occurs when, as a result of a long or intense interrogation, suspects confess to crimes they know they did not commit. This is the most commonly identified type of false confession in criminal cases. In this type, suspects become convinced that the only way to end the interrogation or to receive more lenient treatment is to agree that they committed the crime in question. Sometimes suspects come to believe that, even though they are innocent, the apparently compelling evidence against them will lead others to conclude that they are guilty. They are likely to conclude that accepting the exculpatory scenario suggested by interrogators is the best option for avoiding severe punishment. Other times, innocent suspects come to believe that if they simply agree to the scenario offered by the interrogators, they will be released and will then be able to straighten everything out later and prove their innocence. The 5 confessions in the Central Park jogger case are a perfect example of an instrumental, coerced false confession. Instrumental, voluntary false confessions occur when suspects knowingly implicate themselves in crimes they did not commit in an effort to achieve some goal. For example, a member of a criminal gang or organization may voluntarily falsely confess to a crime to protect someone higher up in the organization. Or a parent may intentionally offer a false confession to protect his or her own child from being convicted of a crime. The goal might even to become famous. Henry Lee Lucas is a good example as that, as he falsely confessed to scores of unsolved murders in an apparent attempt to gain notoriety as the most prolific serial murderer in history. An authentic coerced false confession occurs when, as a product of a long or intense interrogation, the suspect becomes convinced, at least temporarily, that he or she may have actually committed the crime. This, of course, was the case with Thomas Sawyer. In most confessions, the confessor does not develop the false memories, but instead comes to believe that he may have committed the crime despite having no memory of doing so. He may accept the suggestion of the interrogators that he blacked out or that he repressed the traumatic memories of committing the crime. In some cases, interrogators have suggested, and innocent suspects have come to believe, that the suspect suffers from multiple personality disorder and that a separate, submerged personality somehow came out and committed the crime. In authentic voluntary false confessions, They occur when someone suffering from delusions confesses to a crime with little or no pressure from interrogators. In high-profile, well-publicized cases, police interrogators sometimes receive multiple unsolicited confessions from mentally disturbed people who appear to believe they have committed the crime. For example, in the sensational 1947 murder and mutilation of a young actress dubbed the Black Dahlia, more than 50 people came forward to confess to killing her. More recently, dozens of people have falsely confessed to the 1996 murder of John Benet Ramsey. Let's look at some research on false confessions. In a recent study, a group of 71 university students who were told that they were taking part in a test on their reaction times. They were asked to press keys on a keyboard as they were read aloud by another person, who was secretly in cahoots with the experimenter. The volunteers were informed that the Alt key was faulty, and that if it were pressed, the computer would crash and all the experimental data would be lost. The experimenter watched the proceedings from across the table. In fact, the computer was set up to crash regardless, about a minute into the test. When this happened, the experimenter asked each participant if he had pressed the illicit key, acted as if he was upset when it was discovered that the data had disappeared, and requested that the participant sign a confession. Only one person actually did hit the Alt key by mistake, but a quarter of the innocent participants were so disarmed by the shock of the accusation that they confessed to something they had not done. During a second computer crash test, the rate jumped to 80% of innocent participants. The number of innocent confessors jumped when various interrogation techniques were added to the mix. For example, when another person in the room beside the experimenter said he saw the participant hitting the Alt key, that helped increase the innocent confession or the false confession rate. Researchers have attempted to study the impact of a confession by having mock jurors read summaries of 4 types of criminal trials: theft, assault, rape, and murder. Each of these trials contained weak circumstantial evidence plus either a confession, an eyewitness identification, or a character witness testimony. Researchers found that confessions led to a conviction rate of 73%, which was significantly higher than the 59% conviction rate produced by eyewitness testimony. In 2 follow-up studies, confessions were rated as significantly more incriminating than any other form of evidence, and were also rated as the piece of evidence that most powerfully influenced verdicts. In another study in 1997 by Kassin and Sukol, they looked at whether people who were able to discount coerced confessions, they looked at whether people were able to discount coerced confessions. They had mock jurors read 3 transcripts, one involving no confession, one involving a low-pressure confession, and one involving a high-pressure confession. In the low-pressure situation, the suspect confessed right after police started questioning them. In the high-pressure situation, the subject was said to be in pain with their hands cuffed behind their back, and one of the police officers waved their gun in a menacing manner. They found that mock jurors had no problem recognizing that the high-pressure confession was coerced, and the jurors reported that they disregarded this as an involuntary confession. However, and this is important, the jurors' verdicts indicated otherwise. In the low-pressure condition, 62% of the jurors found the defendant guilty, whereas in the high-pressure condition, 50% of the jurors voted guilty, and in the no-confession condition, only 19% of the jurors voted for a conviction. In other words, even a clearly coerced confession raised the rate of conviction by 31%. These findings are consistent with other research on false confessions. In a study of 125 actual, real cases in which DNA evidence exonerated the person, they found that when suspects falsely confessed, then pled not guilty and proceeded to trial, they were convicted 81% of the time, In other words, even though the confessions were false, jurors were not able to recognize them as false. Knowing what we know about false confessions and interrogation techniques, should investigators be allowed to lie to suspects? Currently in the United States, it is permitted. However, in England and Wales, it is prohibited. In fact, all interviews with subjects at police stations in England and Wales must be audio recorded so that lawyers, judges, and jurors can evaluate them. Additionally, they are required to call in an appropriate adult to witness the interview if they are questioning someone who is deemed vulnerable. So far, it is unclear whether these interventions in England and Wales have contributed to less false confessions and more true confessions. Regardless, it raises some interesting questions, such as should lying by police to suspects be permitted if it sometimes results in a true confession? Does this make the possibility of getting a false confession worth it? Would there be fewer false confessions if police were not permitted to tell lies? Would banning such practices then end up in large amounts of criminals avoiding conviction? These are all very tough questions to answer. However, one thing is for sure. There has been some movement towards implementing some sort of video or audio recording in the interrogation room, as well as limiting the time limits on interrogations. Some movement has been made to allowing expert testimony on false confessions at trials that involve confessions. One way to protect yourselves is by knowing your Miranda rights. These were established in 1966 through the Miranda v. Arizona case. The court determined that police interrogations were inherently coercive by their very nature, and crafted a clause of rights to protect citizens. In a nutshell, your Miranda rights are: you have a right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. And you can decide at any time to exercise these rights and not answer any questions or make any statements. Unfortunately, there is little evidence that this doctrine has caused a drop in the rate of interrogations that result in confessions, and very few confessions are ever excluded as a result of violations of the Miranda doctrine. Studies have found that suspects with no criminal records are more likely to waive their Miranda rights, partly due to an illusion of transparency. That is, they overestimate how their inner states of goodness will be observable to the outside world. For example, how the lack of a criminal record or any evidence to suggest that they've ever been violent will somehow show through and show that they're innocent. Moral of the story, do not ever give up your Miranda rights. If you are asked to be questioned by the police, ask for a lawyer. I cannot stress enough the importance of protecting yourself and not giving up these rights. For the rest of this module, I would like you to watch the Frontline documentary, The Confessions. I know that it's long, but I think it's really important for you to be able to see how a false confession can happen and how it can get distorted throughout different aspects of the legal system.